Okay, this is the 140-160 class. We're going to do some congressional warm-up. Okay. For the record, Mr. President, how many times have we heard the same line? If ordinary Americans can balance their family budgets, if state governments can balance their budgets, and if businesses can balance their budgets, why can't the federal government? It is a good question. The real answer is that families, states, and businesses balance their operating budgets most of the time, but they also borrow for long-term investments. Families borrow to buy a house. They borrow to buy a car. States borrow for capital projects that will benefit future generations. Every day, individuals borrow to invest in their future by taking student loans. If they did not, most would have no future, especially in today's increasingly technological age. That is why they do not balance all receipts and expenditures. They balance only their operating budgets. By contrast, Mr. President, this amendment lumps the capital and operating budgets together and makes no distinction between investments and operational expenses. This ignores the basic standards of budgeting under which virtually every business in America operates. As a former CEO of a major public corporation, Mr. President, I can attest to that. Commingling the capital and operating budgets threatens to rob us of investments that are critical to our nation's future. Mr. President, investments are necessary in our nation's roads, in our bridges, in our airports, in our air traffic control systems, in the information superhighway, and the technology of tomorrow. To ignore these kinds of investments is to ignore our own future. We hear it said many times that if we do not have the balanced budget amendment, we are delegating to our children and future generations huge obligations to repay debt, interest, and principal. Mr. President, as we all know, if you do not make investments in tomorrow, that really deprives our children and our grandchildren of opportunities to learn, to earn, to work, to develop. That is when the real penalty to our children and grandchildren is going to come into place. And we can do something about it. We can reduce our spending, and we can proceed to a closer balance of our budgets. We have seen in the last few years with the President's leadership, we have been able to substantially cut our annual deficit somewhere around $500 billion over the 3-year period as contemplated. This amendment also violates a fundamental principle on which our nation was founded, and that is the principle of no taxation without representation. The balanced budget amendment is intended to encourage the Congress and the President to agree on measures to eliminate the deficit. But what happens if the two branches disagree? What happens if, notwithstanding the amendment, the budget is still not in balance? The answer, most likely, at least as presently designed, is that the courts eventually would step in to implement the constitutional requirement. That could mean not only cuts in Social Security, Medicare, and other federal benefits, but substantial tax increases. Some proponents of a balanced budget amendment may say that that is not their intent, but the courts will not be able to rely on such claims. First, there is real disagreement among amendment proponents, and some insist the courts must enforce the amendment. More importantly, there is nothing in the amendment itself that seeks to preclude the courts from enforcing the amendment's provisions. This contrasts starkly with other versions of a balanced budget amendment. And so the obvious question for the courts will be, if the amendment is not intended to preclude judicial enforcement, why does it not include an explicit statement to that effect? Mr. President, the court's power to interpret and enforce the Constitution has been well established since the famed case of Marbury versus Madison. That long established power is not likely to be relinquished. So, Mr. President, the threat of judicial taxation under a balanced budget amendment is not hypothetical. It is very real. And that is not just my opinion. Legal experts of all political stripes agree. The conservative former Supreme Court nominee, Robert Bork, who also opposes the balanced budget amendment, has warned that the amendment could lead to tax increases mandated by unelected lifetime tenured judges. Mr. President, over 200 years ago, this country was born after citizens were burdened with stiff tax increases imposed by distant elite rulers who did not represent the people and who were unaccountable to them. The rallying cry of our oppressed forefathers was clear and compelling, and that same rallying cry applies to this amendment. No taxation without representation. It is permanently embedded in the earliest of our school children. They know about that episode in American history. They know the impact that had in the creation of this wonderful democracy of ours. Mr. President, it is bad enough that ordinary Americans are now paying an unfair portion of the tax burden, but that burden may get a lot heavier when judges inherit the task of balancing the budget. After all, the judiciary is the branch of government that by design is most insulated from the public. In fact, judges are supposed to ignore public opinion. Mr. President, if we think the American people are angry today, just wait. Wait until they get hit with a huge tax increase by a district court judge who they have never heard of, never voted for, and they will never be able to vote out of office. The reaction will make the famous Boston insurrection look really like a Tea Party. I know that some amendment proponents are convinced that the courts will not intervene to enforce this amendment, but supporters of the amendment cannot have it both ways. If this amendment really will force Congress to reduce the deficit, who is going to force us, if not the courts? After all, Congress has already passed laws to force itself to balance the budget, but without any effective enforcement mechanism, we simply sidestepped our own law. And now amendment proponents assure us that the same evasion will not be possible under a constitutional amendment. But just as prohibition did not stop drinking because it was unenforceable, a balanced budget will not stop spending if courts are important to enforce it. I find it absolutely astounding to hear amendment proponents argue that the courts would never enforce this amendment. We are talking about an amendment to the Constitution of the United States, not a sense of the Congress resolution. Can the proponents really believe that the balanced budget amendment is nothing more than a meaningless scrap of paper that cannot be enforced? Could they really be that cynical? I do not think so, Mr. President, and I do not think the courts will either. As Lawrence Tribe and Robert Bork concluded, the courts will not presume that this is a meaningless and utterly enforceable scrap of paper. And that is why the threat of judicial taxation is so real. Mr. President, there is no need to rely on the judiciary to reduce the deficit. Congress could do it. We could start now if we had the political will. Okay, this will be some jury charge practice. For the record. Ladies and gentlemen of the jury, throughout these instructions that I am about to give you concerning the charges, I will more than likely use terms that have a specific legal meaning to them. I do not like to stop and define those terms every time I use them, so I am now going to give you the definitions of some of the terminology that you will hear in the remainder of these instructions so that you have a clear idea what I am talking about. These definitions will apply throughout the rest of my instructions. They may also apply whenever these terms are used later on, unless the topic of the information being delivered to you has some other meaning that applies. Now, we don't expect you to get out your dictionaries and look up every term. If you have a problem with some term or the wording of a sentence or whatever, just let me know. The term false means untrue. Most statements or representations are false if they are untrue. But in the courtroom, a statement may also be false if it conceals another fact. According to Webster, false refers to anything that is not in essence that which it purports to be, and may or may not connote a deliberate deception. False means untruthful, lying, or being dishonest. False can also mean misleading, as to mislead in the presentation of facts. The term fraudulent is closely related to the term false. A statement or representation may be false or fraudulent when it constitutes what is known as a half-truth. A statement may be fraudulent if it attempts to conceal a material fact. Fraudulent acts are done with an intentional deception to cause a person to give up something. Fraudulent acts are done with deceit and trickery with the intention to cheat. Ladies and gentlemen of the jury, let me define the word intent. Intent means to act on purpose toward a specific result. Intent is shown by inference, action, or circumstance. Intent means firmly directed or fixed or in earnest pursuit toward a specific goal, object, or act. What does the term knowingly mean? Knowingly means that the act was done in a voluntary manner. The act was intentional. The act took place not because of some accident or mistake. The act was deliberate and intentional with full awareness of the possible outcome. The person knowingly performed the act. Ladies and gentlemen of the jury, what is a material fact? A fact is material if it has a natural tendency to influence a person or is capable of influencing a person to whom it is addressed. A material fact is important enough to affect the outcome of a case. A material fact is important enough to determine the validity of a legal instrument. Ladies and gentlemen of the jury, what does the term willfully mean? Willfully means that the act was committed on a voluntary basis. The act was done purposely with the specific intent to do something that the law forbids. The act was completed with the goal in mind of either disobeying the law or disrespecting the law. Now, throughout the instructions, you will notice that we use the word and sometimes we use the word or. These are little words, but they can have a profound meaning on a sentence, on the testimony, and on the outcome of the trial. Both and or are considered conjunctions. They connect words, phrases, and clauses to give meaning to the sentence or the paragraph or the material that is presented. The word and means everything or everyone. If you say John and Mary and Susie using the connector and, you are saying everyone or everybody. John and Mary and Susie are connected by the word and given equal weight. If you said the rope and the knife and the gasoline using the connector and, this would mean all items are included. Now, ladies and gentlemen of the jury, the word or means one or the other, not all three. If you say John or Mary or Susie, what you are really saying is that one of them is involved. All three are not involved when the word or is used. Well, I hope my vocabulary lesson will help you as you listen to the jury instructions. Thank you again, members of the jury, for your attention.